I want to thank you very much for taking the time to watch this video. I want to talk to you today about gaining vacant possession in residential rental units. And I recognize that this video is going far and wide. It may be you're not living in the province of Ontario. You could be in anywhere across the country in Canada or down in the US. And the restrictions vary from jurisdiction to jurisdiction. For example, I know that the city of San Francisco and the city of New York have fairly restrictive controls on what you can do as far as rents. Other places it's wide open. So you need to check with your local state or province to find out the requirements. We're going to be talking about the Residential Tenancies Act and how it applies in Ontario. We are under the Residential Tenancies Act. And I should start by saying that housing in the province of Ontario has gone up radically in the last few years. Even with the settling of prices over post-COVID era, we're still double what prices were, say, 7 years ago. And along with the increase in prices is an increase in rent. And so the amount that a landlord is charging for rent today as market rent is probably at least double what the rent would have been 7 years ago. But the rent, as far as the reasonable rent that a landlord can charge, has not kept pace, and the reason for that is rent controls. The province of Ontario sets the guideline as to how much a landlord can increase the rent from 1 year to the next for an existing tenant. It generally comes in at about 2% a year. They try and hit it about the cost of living, but it's usually a little bit less. In fact, during COVID, 1 year at least, there was no increase. Another time it was 1.2%. Another time it was 2.2%. But we'll say on average, maybe you'll get 2% increase from year to year. There was a time under legislation in the province of Ontario that even if a tenant moved out and a new tenant moved in, the legal rent for that unit was locked in to whatever the increase was. That's not the case any longer. Now, if a tenant moves out, it's fair game. You can charge whatever you want. The problem is a lot of tenants don't move out. I want to give you an example. Let's suppose the rent, the market rent back 7 years ago on an apartment you had was $700 a month. And let's suppose you applied the maximum amount you could increase the rent every year by the government guidelines. By this year, you might be up to $800. But the market rent for that unit might be $1,500 or $1,600. So if you're an existing landlord and you know what current rents are, you're realizing every month you're receiving far less than you could be receiving. But where it's really critical is if a new buyer enters the scene. See, he's paid market price for the unit, for the building, whatever it might be. And he needs an offsetting market rent to make the whole thing work. But he's got a tenant in there, and the tenant is paying old historic rent. So what the buyer of the property wants is vacant possession. He can't raise the rent while the existing tenant is in there more than the guidelines. But if he can get the tenant out, he can charge market rent. So the question we get in real estate often is, how do we get rid of the tenant? How do I get vacant possession? And often they'll put that right in the agreement of purchase and sale. The seller agrees to provide vacant possession. But it's not that simple. How do you do it? You can't just evict a tenant because you kind of want to raise the rent. You can't just raise the rent because it's a new owner. There are a couple of legal ways. I mean, I'm not talking about a tenant who isn't paying his rent, chronically causing problems, damaging the unit. There's a couple of ways that you can evict a tenant because you want to raise the rent. But you got to be very careful that you're doing it legally and properly. The first thing is that the Residential Tenancies Act gives provision for a tenant to be evicted with 60-day notice if the property is required by the owner or his immediate family. And when we say immediate family, it's very specific about it. It can be child, or it can be parent, or it can be spouse. It can't be brothers and sisters or uncles and aunts and so on. If immediate family or yourself as the owner requires the property to live in yourself, you can give the tenant notice to vacate, and you set him a notice called an N12. And the N12 at the start of a payment period, probably the first of a month, gives him 60 days to find a new place. And you give them the reason because you need it for your own self. And you're allowed to do it for the person who has a beneficial interest in the property. What that means is somebody who's buying the property to move in, he requires it. And so if you have an agreement of purchase and sale in place, you as the landlord can give notice. So if you're the buyer buying a new property, you can state in the agreement of purchase and sale that the seller agrees to give the prerequisite notice requiring vacant possession from the tenant. Put that in there. You're allowed to do that. There's some things you need to be aware of, though. Certainly, as you're the existing owner, you're required to pay them a consolation of 1 month rent. They can leave anytime within that 60-day period. In other words, if they find another place 2 weeks from now, they don't need to give you any notice. They can move out. And there are stiff penalties involved if you are inappropriately giving them that notice. In other words, if you're telling them, I need it because the new owner requires it for his own use, but it's a ruse to actually rent the property at market rent, the existing tenant can come back anytime within the next 2 years, lodge a complaint, and there's not only stiff fines, but the landlord has to make the unit available to that existing tenant at the existing rent, even if he spent a bunch of money renovating and updating and painting and repairing it and so on. So you got to be careful about that. The second possibility is using something called an N11. And an N11 is a negotiated agreement. This is where you as the owner, landlord, perhaps are selling the unit and you say, I've got a buyer who wants to renovate, paint, fix it up, and he's going to charge market rent. So I'd like you out, and I'm willing to pay you to move out. And if you can come up with an agreement that you both agree on, you as the seller, it might make sense. Maybe you're getting enough money for your property that you can afford to pay the tenant $4,000 or $5,000 consolation to have him move out. If he agrees, both parties sign an N11, and then you register that with the landlord and tenant board so that the eviction process can be underway just in case the tenant doesn't move out. And that brings me to the last thing, and that is what happens if the tenant doesn't move out. You give him the 60-day notice, but he's not going to move. We had a situation recently where somebody from the West was moving in, they were buying a property, and they were closing the first of the month. It was actually the 1st of July, and so the landlord gave the existing tenant 60-day notice requiring them to move out the 1st of July. That tenant bought another property instead of renting again, and they set it up that they were going to close the middle of July. And the reason they did that was they were going to be away on holiday, and the 1st of July just simply wouldn't work. So they weren't going to move out by the 1st of July. And in fact, they called the residential tenant board, and the board said, get this, in spite of the law, the board said to them, oh, don't worry about it. It'll take them months to evict you. You don't have to move out to the 1st of July. And they didn't. And so you have to, if you're a buyer and you're buying a property, even if the landlord has given the prerequisite 60-day notice, or even if the tenants agreed and signed an N11, you can never covenant what somebody else is going to do. And so the agreement of purchase and sale has to contemplate that. What happens if they don't move out? Generally speaking, you need to have a clause in there that addresses that. Either the agreement becomes null and void because otherwise the seller's in breach because he's not providing vacant possession, or the buyer agrees to close the property, assume the tenant, and take over the eviction process. But it needs to be addressed. And if you're the existing landlord, you need to understand there's right and wrong ways to do it, and you need to do it the right way. And if you're a buyer, you need to understand there's no guarantees, and unless it's vacant now, you'd like to get it vacant, you may or may not. But don't use a ruse and pretend that you're going to be needing it for your family and just paint and freshen it up and throw it on the market for rent. The existing landlord could be very, very liable, and so could you. I want to thank you very much for taking the time to watch this video. Talk to you again next week.